This is Fighting for What's Right. I'm Pam Jones, here with personal injury attorney Barry Doyle. So Barry, once a lawsuit is filed, how long does it actually take to reach trial?
That's going to vary depending on which county your case is being heard in. Each county has its own separate court system, and some counties are faster than others at getting cases to trial. On average, from the time you file a lawsuit until you get in front of a judge and jury in Cook County, which is where Chicago is, you're typically talking about a 2.5-year window. Now, that average can vary depending on, is it a relatively simple case like an auto case, or is it a really complex case like a multi-party medical malpractice case or construction accident case or something along those lines, which can take 4 or 5 years to actually reach trial. So that 2.5-year average that's an average, but there are outliers on either side. What really counts is what kind of work has to be done to actually get the case ready for trial.
So Barry, what's the first thing that happens after the defendant gets served with a lawsuit?
Well, the first thing is that they have to file an appearance from their lawyers in the answer to the complaint, which, like I said, is almost invariably a denial of the allegations. But after that, there's a stage that's called written discovery. And basically what written discovery is it's an exchange of written questions and a request for documents. So if I'm representing someone, I send a set of written questions and requests for documents to the defense lawyers. They send a request for documents instead of written questions for me.
So what kinds of things get asked during the written discovery process?
Well, when you're talking about the questions that I'm answering, it's usually a request for medical records and bills and photographs, witness statements, things along those lines. There are typically questions about prior lawsuits, prior accidents, prior medical history that is kind of relevant to the injuries that are being claimed. When I send a set of written questions and a request for documents out to the other side, it's going to vary depending on what kind of case is involved, but generally what you're asking for are things like witness statements and photographs, but then also documents that are really relevant to the issues in the case, and those are really going to vary depending on what kind of case. In an auto case, that may be just a handful of documents like an estimate of the property damage for the car, but in a case like a construction accident case, that may be literally boxes and boxes of documents. But that's what the written discovery process is, and it can take a long time sometimes.
And is some of that time that it takes also because sometimes the scope is too grand that the other party's asking for, like the people that are being sued are asking for way too much information about your client?
It goes both ways. I mean, sometimes they ask for things that really are not directly relevant, which are actually protected, like things like your mental health history. But then on the side where the defense is answering, sometimes they feel like I'm asking for too much, and they're claiming that there are documents that they shouldn't have to produce. And when we get into those kinds of disputes, then those are issues which the judge will ultimately have to make a ruling on and say, yes, you have to answer that, yes, you have to turn over that document, or no, you don't. But this is something which can take a while, depending on what the issues are in the case and the approach the other lawyer takes to defending that part of the case. The reason that getting through this written discovery stage of the case is important is because it kind of sets the table for the next part of the case, which is doing depositions.
Thanks, Barry. This is Fighting for What's Right with personal injury attorney Barry Doyle. For more information, visit our website at www.fightingforwhat'sright.com.